Good evening, friends. We have Justice V. Ramkumar, a former judge from Kerala High Court, and he has started a new series, understanding the concepts in a deeper dive, which we always learn from Justice V. Ramkumar. Yesterday, we had exchanged few WhatsApp chats wherein Justice V. Ramkumar's knowledge was being praised on the live law. I had shared that certain people had shared and appreciated his style of sharing his knowledge on the Beyond Law CLC. And today's session is Warrant Trial by Magistrates, instituted on a complaint. And we are thankful to Sir, despite the fact that he's with his son-in-law and daughter in Dubai. He keeps on sharing his knowledge, and we are also thankful on behalf of Beyond Law CLC team to their son-in-law and daughter who have acceded to his knowledge sharing concept to continue. I understand with this concept, they also have to get tied up till the entire session continues. Thank you, and over to you, sir.
Thank you, Mr. Vikas. Good evening, friends. Today's session, we have come to the last of the magisterial trials. We have seen the summons trial in a case instituted on a police report. We had seen summons trial in a case instituted on a complaint. Last session, we saw warrant trial in cases instituted on a police report. All trials are magisterial trials. Today we have come to the last of the magisterial trials. That is warrant trial in cases instituted on a private complaint. All are magisterial trials. Now, warrant trial by magistrates is dealt with under Chapter 19 CRPC. This Chapter 19 is in three parts. Part A, Part B, and Part C. Part A, comprising of sections 238 to 243, deals with cases instituted on a warrant cases instituted on a police report, which we have examined during the last session. Part B, that is sections 244 to 247, deals with warrant cases by magistrates instituted on a private complaint, which is our present session. Then Part C, that is section 248 to 250, is a common part applicable both to Part A and Part B. Now, we will start with the provisions. The relevant provisions are: one is section 204, section 204, subsection 3, that is issue of process. The object of this provision is to enable the accused to know precisely what is the charge against him. Subsection 3 of section 204 has been held to be only directory, even though the word used is shall. And non-compliant thereof does not vitiate the issue of process. And a copy of because according to section 204(3), every process, every summons should be accompanied by a copy of the complaint. Even if it doesn't accompany, it is not fatal. It is held to be only directory and not mandatory. Therefore, it is enough if after the appearance of the accused, copy of the complaint is furnished to him. This is the view taken by the Bombay High Court in Pramila Mahesh Shah versus Employees State Insurance Corporation, 2002 Criminal Law Journal 2454, 2002 Criminal Law Journal 2454, Bombay. The author of the verdict is Justice R.K. Bhatta. Now, first section relevant for warrant trial is section 244. Warrant trial on a private complaint. 244. The prosecution, as and when the accused appears or is brought, the prosecution is bound to examine all its witnesses. See, this is a novel procedure. Till we have seen in all the other three magisterial trials, as soon as the accused appears, as soon as the accused is before court, before the magistrate, the magistrate proceeds to frame the charge or read the substance of accusation. If it is a summons trial, substance of accusation. If it is a warrant trial, frame the charge. So as soon as the accused is before court, the magistrate will proceed to read the substance of accusation or frame the charge, depending on the nature of trial. In all the three magisterial trials which we consider till now. But for the first time, you find a deviation in a warrant trial in cases instituted on a private complaint. The reason is in every case instituted on a police report, in view of the investigation by the police, there will be statements of witnesses under section 161.3, recorded under section 161.3 CRPC. Therefore, when the case goes for trial, the accused is in an advantageous position because he has the statements of all the prosecution witnesses recorded by the police officer during the stage of investigation. Whereas in a warrant trial private complaint, it's a private complaint. There is no police investigation. Therefore, the accused will be in a disadvantageous position. That is why the framers of the code thought it fit to take the evidence, prosecute evidence in the first instance itself. As and when the accused is before court, section 244 says the prosecution witnesses, all the witnesses should be examined so that there will be statements of all those witnesses with which the accused can effectively cross-examine the prosecution witnesses. This advantage will not be there. This advantage the accused will be having in all the police charge cases because police have already examined witnesses and recorded their statements under section 161.3 CRPC. That facility or that advantage is lacking in a warrant trial private complaint case. That is why, as and when the accused appears or is brought before court, the law says, section 244 CRPC says, all the prosecution witnesses shall be examined. This is called the pre-charge examination. Pre-charge examination. And the accused, since the accused is already before court, pursuant to receipt of summons, he has the option to cross-examine those prosecution witnesses or not to cross-examination. It is left to him. Option is with the accused. This is called the pre-charge cross. We generally call pre-charge cross. Now, even before the examination of all the prosecution witnesses, as soon as the accused appears, the accused has got the right to seek for a discharge under section 245(2). Under subsection 2 of section 245, the accused can say, even before examination of all the prosecution witnesses, see, the complaint does not make out any offense. Your Honor, Magistrate, you should not have issued process to the accused because the complaint itself does not make out any offense. Therefore, the accused can ask for a discharge even before the examination of the prosecution witnesses due to any defect in the complaint, private complaint. Then, supposing there is no such defect and accused does not invoke or exercise his power under section 245, subsection 2 CRPC, the prosecution witnesses will have to be examined. After the examination of all the prosecution witnesses, the accused gets one more chance to cross-examine the prosecution witness. This is called the post-charge cross-examination. Then after the post-charge cross-examination, also he can seek for a discharge. Now, after 245(1), that is 245(1) discharge. After the examination of all the prosecution witnesses, accused can ask for a discharge. If the accused is not discharged under section 245(2) or under section 245(1), then the court has to frame the charge under section 246, clause 1, subsection 1. The subsection 1, if the accused is not discharged under section 245, the court shall, the magistrate shall frame the charge. This is called the post-charge post post charge examination. I'm sorry. After framing the charge, the court will have to ask the accused under section 246(2) whether he pleads guilty or not. Under section 246(2), because once the charge is framed, what is the purpose of charge? To tell the accused that you are prima facie, this offence is made against you. This offence is shown you appear to have committed this offence. Therefore, I am charging you with these offences, CRP, IPC offences or non-IPC offences. And what have you got to say? His plea is to be taken. Once he pleads guilty, that magistrate has to see whether the plea has been made voluntarily. Voluntarily means of his own accord, without any extraneous pressure or influence. If the magistrate is satisfied that his plea of guilt is voluntarily made without any influence or pressure, then the magistrate has got the discretion to convict him straight away, find him guilty straight away, and impose an appropriate sentence. But mind you, it is in his discretion. Magistrate has got the discretion to convict him or not to convict him. That's therefore, even in a case the accused voluntarily pleads guilty, the magistrate can call upon the prosecution. No, I'm not satisfied with it. He is ignorant. Maybe he doesn't know the consequences. He is ignorant. Prosecutor, you adduce your evidence. The magistrate can call upon the prosecution to adduce evidence and prove its case. So that discretion is always there in the magistrate. Then, therefore, if the magistrate is satisfied that the plea of guilt has been voluntarily made, and then the magistrate can convict him under section 246, subsection 3. Then we come to section 246, subsection 4. If the accused does not plead guilty, supposing the accused says, no, I don't plead guilty. This is not an offense committed by me. I am not guilty. I plead not guilty. Or if even after the accused pleading guilty, the magistrate does not convict him in his discretion, then we come to the next stage. The magistrate shall ask the accused whether he wants to cross-examine any of the prosecution witnesses already examined. This is really called the post-charge cross-examination. Already if charge has been framed under section 246(1). Now the magistrate asks him whether he pleads guilty. He says, I am not pleading guilty. Or the magistrate has not convicted him under section 246(3). Then under section 246(4), subsection 4, the magistrate asks him, do you want to cross-examine any of the prosecution witnesses who are already examined under section 244? Now, I told you, even while the initial examination under section 244, the accused has got the right of cross-examination, which he may exercise or may not exercise. Now, this is the second opportunity in a warrant trial private complaint. The second opportunity is to cross-examine after the framing of charge and after the accused is not found guilty and he is pleading guilty. He is not convicted on his pleading guilty. Then he will examine, he can recall any of the prosecution witnesses already examined and he can cross-examine them. Then comes the next stage, 246(5). 245 the actual cross-examination by the accused. Then comes the next stage, 246(6). Prosecutor can now examine the remaining witnesses. See, prosecution examined only some of the witnesses under section 244. They have been cross-examined also now. Now, if there is any remaining witness, then the prosecution can examine those remaining witnesses under section 246. 246, subsection 6. Then comes the next stage, 247. 247 is prosecution evidence is over. Once prosecution evidence is over, what is the next stage? Supposing there are incriminating evidence or incriminating circumstances in the evidence for the prosecution, the magistrate is bound to examine the accused under section 313(1) CRPC. This is not only a statutory right, a right emanating from the principles of natural justice. Odi alterum partem. No person shall be condemned unheard. Therefore, when there are incriminating circumstances in the prosecution evidence, the magistrate is bound to put every one of those circumstances to the accused so as to give him an opportunity to explain. And courts have gone to the extent of saying that if any particular incriminating circumstance was not put to the accused during his examination under section 313(1)B CRPC, the magistrate is not entitled to utilize that particular circumstance for convicting the accused, and that conviction will be bad. Courts have gone to that extent. That is the relevance or importance of 313 examination. Now, and examination, courts have even, this humble self has taken the view that while putting questions, very simple questions have to be put. Each and every incriminating circumstance has to be separately put by simple questions so that he can answer effectively. And after 313 examination, only the case will be posted for defense evidence. Unlike the sessions, like summons trial on a police report and summons trial in a complaint case, in a warrant trial, the accused has got the right to be called for evidence. In fact, he has a right to be called upon to enter on his defense. Whereas in a summons trial, whether on a private complaint or on a police report, the accused does not have the right to be called upon to enter on his defense. Whereas in a warrant trial, where the offences are graver offences, punishable with imprisonment for more than 2 years. In those offences, the magistrate is duty bound to call upon the accused to enter on his defense. Whereas in summons trial, the magistrate may ask, have you got defense evidence? That's all. Even that is not, the magistrate is not bound to ask the accused. The accused has to volunteer that I have got defense evidence. Whereas here, the magistrate should be called upon to enter on his defense under section 247. Then, after the defense evidence is over, the magistrate will evaluate the entire evidence. And then, if supposing there is no, the alleged offense is not made out, then the magistrate will have to pass an order of acquittal, which is on merits under section 248(1). But supposing there is evidence, enough incriminating evidence against the accused, and he can be made liable for the offense alleged against him, the court has to convict him after evaluating the evidence on merits. This conviction is under section 248, subsection 2, unless the magistrate proceeds under section 325 or under section 360 CRP. What is 325? 325 is if the magistrate after trial finds that this particular accused should receive more severe punishment than I can inflict. The first class magistrate can inflict imprisonment only up to 3 years and fine up to 10,000. Now the magistrate feels that no, he should receive imprisonment for more than 3 years, which I cannot award. Then he can exercise his power under section 325 CRPC and make over the case to the Chief Judicial Magistrate. The Chief Judicial Magistrate, on receipt of the files, will have to further trial, to conduct further trial and dispose of the case accordingly. That is the power under 325. So, if after the trial, if the magistrate finds that the accused is liable to be punished, then if he doesn't exercise his power under section 325, he has to find the accused guilty of the offense and impose a sentence. Likewise, if the magistrate does not exercise his power under section 360 CRPC, 360 CRPC has now become redundant because in almost all states, the Probation of Offenders Act 1958 has been extended. Once the Probation of Offenders Act 1958 has been extended, then 360 need not be complied with. It is mandatory for the magistrate to comply with section 3 or 4 of the Probation of Offenders Act 1958, under which the accused can, if he is a first offender, he can be either sent after admonition. Sorry. He can be let off after giving an admonition, or he can be released on probation for good conduct. Probation of good conduct for a particular period, for example, 6 months or 1 year. Instead of awarding the sentence on him, the magistrate will release him on probation. The magistrate will tell him, you execute a bond and I am releasing you on probation for 6 months. If during this 6 months you behave properly, I will ask the district probation officer to keep an eye on you. And if you behave properly, then I will not be imposing any sentence. But if your conduct is otherwise, I will be imposing adequate sentence on you. That is, in these two provisions, if the magistrate does not invoke, then the accused has to be inflicted the appropriate punishment, imprisonment and fine, or imprisonment on fine. Then we come to section 249. Absence of complainant. Absence of if the accused is the complainant is absent and is continuously absent, then the accused is undergoing the trauma of a trial for no fault of his. Every time when the case is posted, complainant is absent. So in such a case, and if the in spite of the court making available to the accused, in spite of the court taking all steps to make available to the accused the prosecution witnesses for cross-examination, if the magistrate has failed in spite of issuing coercive steps to those witnesses, then that will be a fit case where the magistrate will be entitled to discharge the accused. And that is under section 249, where the complaint. But it can be done only in compoundable offences or in non-cognizable offences. This can be done only in compound offences which are compoundable under section 320 CRPC, or non-cognizable offences. Non-cognizable offences means you have to search for column 6, column 5 or 6, 4, column 5 of the first schedule to CRPC to find out whether the offence is cognizable or non-cognizable. If the offence is non-cognizable and if the complainant contumaciously remains absent and the witnesses are not made available for the accused to effectively cross-examine them, then the court will be justified in discharging the accused. Then last section is section 250, compensation for accusation without reasonable cause. Compensation for accusation without reasonable cause. Now we will examine a few case law on this subject. Now, with regard to the right of the accused to cross-examine the prosecution witnesses under section 244, as and when the accused appears, the prosecution has to examine all its witnesses. Now, since the accused is present before court, he cannot deny the right of cross-examination. Unlike in other cases, in the earlier cases, where the accused appears only after cognizance and only after summons. Here he has appeared, and in all other cases, the examination of the accused, of the witnesses, prosecution witnesses, commences only after the plea of the accused is taken. But here, even before the plea of the accused is taken, prosecution witnesses are examined under section 244 CRPC. Since the accused is present before court, he has got the right of cross-examination. Now, you may remember a private complaint filed under section 200, section 190, if the magistrate is recording the sole statement of the complainant and his witnesses during the course of taking cognizance, the accused has no right at all. The accused has no right of hearing at all, because the magistrate is yet to issue process. He is in the process of taking cognizance. At that stage, the accused has no right to be present. And courts have taken the view, right from 2004 Supreme Court onwards, that even if the accused happens to be present in court, in the magistrate court, he has no right of cross-examination. He has no right to participate in the trial. He can only simply sit there and watch the proceedings. Because he has not been called, invited to the court. He will be invited to the court only after the magistrate examining the complainant and his witnesses decides to issue process to the accused. Once process is issued to the accused, he is invited to the court. The accused is told to appear before this court and answer the charge. Then only he gets a right to address the court. Until then, he has no right. But and quite contrary to that, in a warrant trial private complaint case, instituted a private complaint, since the prosecution witnesses are examined in the presence of the accused, whereas there, and in the presence of the accused, who has a right to be present because he has appeared on summons. In such a case, even though the Kerala High Court in Gopalakrishnan versus State 2001 to KLT 767, corresponding to 2002 Criminal Law Journal 2419, the Kerala High Court, a single judge of the Kerala High Court, took the view that it being a stage of inquiry, the accused has no right to cross-examine the prosecution witnesses. But this decision is impliedly overruled by two verdicts of the Supreme Court in Ajay Kumar Ghosh versus State of Jharkhand, AIR 2009 Supreme Court 2282, corresponding to 2009 14 SEC 115, and Harinarayan G. Bajaj versus State of Maharashtra 2010 volume 11 SEC 520. Now, these verdicts have recognized the right of the accused to cross-examine the prosecution witnesses at the pre-charge stage. Of course, it is open to the accused to cross-examine them or not to cross-examine them. It is up to him. But after the charge is framed, when an opportunity is given, they will definitely cross-examine the prosecution. The purpose of this pre-charge examination of prosecution witnesses is only to give the accused sufficient material on the basis of which he can effectively cross-examine the prosecution witness. Unlike in a police report case, the case instituted on a police. Then under section 245, discharge of the accused at the pre-charge evidence. There were some high courts have taken the view that for discharge under section 245(2) at any previous stage, some evidence has to be examined. Some witnesses have to be examined. No, Supreme Court said no. Even though the said statement has not, it has been held that even before the examination of any of the prosecution witnesses, the accused is entitled on his appearance to tell the magistrate that look at the complaint, read the complaint. There is no iota of averment regarding the commission of a cognizable offence. Therefore, please discharge me. He is entitled to argue that the prosecution witnesses need not be examined. You may. Because discharge is on the ground that charge is groundless. You may refer to Ajay Kumar Ghosh versus State of Jharkhand. I have already given that title. Year 2009 Supreme Court 2282, corresponding to 2009 14 SEC 115. But if it is for framing charge, there has to be some evidence. Without any evidence, charge cannot be framed. In one case, it was held that the mere fact that the complaint was filed 25 days after the period of limitation, the complaint was filed after the period of limitation prescribed for the offence, and that would not entitle the accused to seek a discharge under section 245 because the complainant is under law a right to seek extension of time under section 473 CRPC. Under section 473, the complainant can, even though he has filed the complaint beyond time, he can still seek extension of time, ex debito justitia, in the interest of justice, under section 473 CRPC. This is what the Supreme Court said in Rakesh Kumar Jain versus State AIR 2000 SC 2754, corresponding to 2000 Volume 7 SEC 656. Justice Ketty Thomas and R.P. Sethi. Then the question as to whether charges are to be framed or not has to be considered only after taking all prosecution evidence. Because that is what section 244 CRPC obliges the magistrate and the prosecution. Prosecution has to examine all the evidence, all the prosecution evidence. But in one case, since the prosecution did not object to the court framing charge, it was held that nothing wrong in the court framing charge. It was held in the famous celebrated case R.F. Naik versus A.R. Antole, AIR 1986 Supreme Court 2045, corresponding to 1986 2 SEC 716. In another case, in a prosecution under section 161 and 165 IPC and clauses A or B of section 51 of the Prevention of Corruption Act 1947, it was held that the court must necessarily apply the presumption under section 4 of the PC Act 1947 and should examine the evidence as it stands without rebuttal, and came to the conclusion whether on the basis of such evidence the court would convict the accused. The answer is in the affirmative. A charge should be framed. Again, R.S. Naik versus A.R. Antule, AIR 1986 Supreme Court 2045, corresponding to 1986 2 SEC 715. P.N. Bhagwati, Chief Justice of India, was the author of the judgment. Then, recording of reasons for discharge, whether under section 245(1) or under section 245(2), is a must. Why? Because by discharging the accused, the court is terminating the proceedings prematurely. Court is not framing charge, and court is not going to try the case. Case is going to be prematurely terminated. So court is bound to give reasons. So reasons have to be given. That is what Justice Govinda Menon, P. Govinda Menon of Kerala High Court held in 1966 KLT 306, corresponding to AIR 1966 Kerala 243. The same Govinda Menon was elevated to the Supreme Court. Even same Govinda Menon, P. Govinda Menon. Now we come to section 246 clause 1. Magistrate to frame charge when there is ground for presuming that the accused. What is the yardstick for framing charge? That there is ground for presuming that the accused has committed an offence triable under Chapter 19 CRPC. That is the criteria. Then, trial in a warrant case instituted otherwise than on a police report. That is, trial in a warrant case instituted on a complaint commences with the framing of charge and on the accused pleading not guilty. It's a popular misconception that trial starts with the framing of charge. I have stated ad nauseum that trial doesn't start with the framing of charge, but trial starts only with the framing of charge and the taking of the plea of the accused and the accused pleading not guilty. If the accused pleads guilty and if the plea is voluntarily made, there's no charge, there's no trial. The accused can be straightaway convicted. Therefore, trial starts only when the accused pleads not guilty. And the court calls upon the prosecution to adduce evidence in support of the prosecution. Beautiful judgment by a 3-judge bench. The author of the judgment is R.S. Sarkaria, whom I love very much. Justice R.S. Sarkaria. Ratilal Banji Mitani versus State of Maharashtra. AIR 1979 Supreme Court 94, page 94, corresponding to 1979 to SEC 179, 3 judges. And charge is to be framed. Next decision is charge is to be framed on the basis of the evidence offered by the complainant at the stage of section 244(1). Charge is to be framed on the basis of the evidence adduced by the prosecution witness, including the complainant, under section 244(1) CRPC. Ajay Kumar Ghosh versus State of Jharkhand. This is the third time I am giving the same citation. AR 2009 Supreme Court 2282, corresponding to 2009 14 SEC 115. Author of the judgment is Justice V.S. Sirpurkar. Then another decision. The ground for proceeding under section 241 that the accused has committed an offence should appear from the evidence adduced under section 244 CRP. The ground for presuming that the accused has committed an offence should surface from the evidence adduced under section 244 CRP. Bhavani Shankar Begaria versus Ratul Datta, the Gauhati decision, 1989 Criminal Law Journal 1069. 1989 Criminal Law Journal 1069. Manisana is the judge, Justice Manisana. Now we pass on to section 246(2), that is reading and explaining the charge. The charge framed should be read over and explained to the accused, who should be asked whether he pleads guilty to the charge or has any defense to be made. That is the content of section 246 subsection 2. The charge is so read over should be explained to the accused in the language known to him. It is not enough the court frames the charge in the language of the court. Even if the court frames the charge in the language of the court has to translate the charge into the language known to the accused. Then only he can effectively plead guilty or not. Otherwise, he will be in a most disadvantageous position without knowing the contents of the charge. Then we come to section 246(3), subsection 3, conviction on plea guilty. So if the accused pleads guilty, he has to be convicted. But his plea should be with regard to the ingredients of the offence. Now, supposing the ingredients of the offence are not in the charge, even if he pleads guilty, it only amounts to admission of the facts in the charge. If the charge does not make out the ingredients of the offence, merely because the accused admitted the charge or pleaded guilty, he cannot be convicted. That is the view taken. In the Kerala High Court has also taken that view. Aslam Iqbal Wali Muhammad versus State of Karnataka, a judge of the Karnataka High Court, S.R. Range Gowda, 1976 Criminal Law Journal, 317. In fact, it was held that, now we pass on to section 246, subsection 4, where the accused does not plead guilty or is not convicted under section 246, subsection 3, if on his pleading guilty, a further option for cross-examination of the prosecution witness is to be given to the accused. That is the post-charge cross-examination. Post-charge cross. This is a right given to the accused. Again, I am already given the citation. Ajay Kumar Ghosh versus State of Jharkhand, AR 2009 Supreme Court, 2282. In fact, impliedly overruling the decision of the Kerala High Court. And also Harinarayan G. Bajaj versus State of Maharashtra, 2010, volume 11, SEC 520. Now let us examine the case law under section 246, subsection 5. Further cross-examination after recalling the prosecution witnesses, where the accused wished to have any prosecution witness recalled and cross-examined, his right to do so is an absolute right, and it is an unqualified right. Neither the court nor the prosecution can deny him that right. It is a statutory right and an unqualified and absolute right. Upon the accused expressing his desire or wish to recall and cross-examine any prosecution witness, that the duty to recall such witness is on the magistrate, not merely on the prosecution. Magistrate has got the duty to recall those witnesses and make them available for cross-examination by the accused. This was so held by Justice Kader of the Kerala High Court in Madhusudan Nambudiri versus Unni Nair, 1974 KLT 856, corresponding to 1975 Criminal Law Journal 751. Then based on the section 246, subsection 6, evidence of remaining witnesses for prosecution. It has been held that it cannot be said that words remaining witnesses involve only those which are left out from the first list, not necessarily those which are left out from the first list. But remaining witnesses mean you include already witnesses already examined also. Ragnar Shenai versus S.A. Prabhu, AIR 1967 Kerala 233, AIR 1967 Kerala 233, corresponding to 1966 KLT 994. P. Govinda Menon. Again, he was a great judge on the criminal side, who was later elevated to the Supreme Court. Then, even though the power of the magistrate should not be fettered either under section 244 or under section 246, subsection 6 CRPC, a full latitude should be given to the magistrate to exercise his discretion even in entertaining a supplementary list of witnesses. The discretion should be exercised judiciously and for advancement of the cause of justice, and not to give a handle to the complainant to harass the accused. Supposing the complainant submits a long list of witnesses with the sole object of harassing the accused, the magistrate has got the discretion not to allow him to examine all those witnesses. Saeed Farhana Shamin versus State of Bihar, AR 2008 Supreme Court 2373, AR 2008 Supreme Court 2373, A.K. Mathur is the author of the judgment. Then we come to section 247, defense evidence. Unlike in summons cases, the accused in a warrant trial has the right to be called upon to enter on his defense. This right is available to in a session trial also. So it is also a warrant trial, an enhanced, aggravated form of warrant trial. So this right to be called to enter on his defense is available to the accused in a session trial also. We come to section 248, clause 1, subsection 1 of section 248. Acquittal on merits. If after the charge has been framed and the accused has been given opportunity to cross-examine the witnesses, etc., and he has also been given the right of defense evidence, and the court finds that there is no material on which the accused can be found guilty, then the magistrate can make an acquit the accused of the alleged offences. This is an acquittal on merits under section 248(1) CRPC. Now, a word of caution has been given by the Madras High Court, speaking through Justice Padmini Jesudurai. It was open to him, this is what the learned judge held. Charge framed under section 246(1) CRPC against the accused for offences under section 494 and 495 of the Penal Code. Accused was acquitted merely on the ground that complainant and her witnesses were not available for cross-examination. This was the sole ground on which the accused was acquitted. Held that when the magistrate found that the appellant as well as the witnesses were absent, it was the duty of the learned magistrate to have procured the complainant as well as his witnesses, if need be, even by coercive process, like issuing warrant, etc., and make them available to the respondent, to the accused, for cross-examination, and thereafter proceed according to law. It was not open to the magistrate to acquit the accused merely on the ground that the witnesses already examined by the prosecution were not made available for cross-examination. It is not merely the duty of the prosecution, it is as much the duty of the magistrate also to ensure that those witnesses are made available to the accused for cross-examination, because he has already exercised his option to cross-examine them. Then it is for the magistrate to issue coercive steps, take coercive steps by issuing warrants of arrest, etc., and procure the presence of those witnesses and make them available to the accused for cross-examination. Vasanthi versus Ramaswamy, 1992, Criminal Law Journal 2442. 1992, Criminal Law Journal 2442. Madras High Court speaking through Rukmini Jesudarai. Now, once a charge has been framed and the accused is found not guilty of the offence on merits, an acquittal should automatically follow under section 248(1) CRPC. Once a charge has been framed and the accused was given all the opportunities and the accused is found not guilty or rather acquitted on merits under section 248(1), an acquittal should automatically follow. There cannot be any via media. This is what the Supreme Court cautioned in Harihar Chakravarti versus State of West Bengal, AR 1954 Supreme Court 266, corresponding to 1954 Criminal Law Journal 724. 3 judges. Justice N.H. Bhagavati is the author of the judgment. Of course, this was decided under the corresponding section 258 of the 1898 Code. Similar provision. Now, once an accused is discharged, once an order, the court has got the power to discharge the accused, or if he doesn't discharge, the magistrate doesn't discharge, he can frame charge. Once the magistrate frames charge, the magistrate cannot discharge. If the magistrate discharges the accused after framing charge, he will be going back to the previous stage, pre-charge stage, which a criminal court, including a magistrate, cannot do, does not have the power, unlike a civil court. The magistrate does not have the inherent power, unlike the High Court. Therefore, if the magistrate has framed the charge, he cannot discharge the accused. This is what the Supreme Court famous decision. I have already given the citation. Redilal Banji Mitani versus State of Maharashtra, AR 1979, Supreme Court 94, corresponding to 1979, Volume 2 SEC 179. 3 judges. Justice R.S. Sarkaria, the author of the judgment. The other judges are O. Chinnappa Reddy and A.P. Sen. In yet another case, after the charge has been framed, the only order that can be passed is either conviction or acquittal, and not an order of discharge. Yeah, same principle, which the Supreme Court said way back in 1979, is laid down by the Kerala High Court, speaking through Justice S.K. Kadar. State of Kerala versus Sebastian, 1982 KLT 724, corresponding to 1983 Criminal Law Journal 416. Then, an order of acquittal passed by the magistrate without ascertaining the presence of the witnesses and without any genuine effort made by the magistrate to secure their presence was without jurisdiction and was set aside. The same principle which was laid down by the Madras High Court. An order of acquittal passed by the magistrate without ascertaining the presence of the witnesses and without any genuine effort made to secure their presence was without jurisdiction and was set aside by the Kerala High Court, speaking through Justice Chetur Shankaran Nair in M. Narayanan versus Kunyambu, 1987, Volume 2, KLT 94, corresponding to 1988 Criminal Law Journal 1375. 1375. Now we come to section 248(2), finding the accused guilty on merits and passing a sentence on him, unless section 325 or 360 are invoked. There's not much of a case law on this, but I have already highlighted the provisions. And the court will be failing in its duty if appropriate punishment is not awarded for a crime which has been committed not only against the individual victim, but also against the society to which the criminal and the victim belong. The punishment to be awarded for a crime must not be irrelevant, but it should conform to and be consistent with the atrocity and brutality with which the crime has been perpetrated, the enormity of the crime warranting public abhorrence, and it should respond to the society's cry for justice against the criminal. This is what the Justice Arijit Prasad observed in State of Madhya Pradesh versus Salim alias Chamaru, AIR 2005 Supreme Court 399, AIR 2005 Supreme Court 3996, corresponding to 2005, Volume 5 SEC 554. Justice Arijit Prasad and Justice S.K. Kapadia, Prasad being the author. Then we come to the case law on section 248.3, how to frame charge for previous conviction. 243, supposing the accused is a hardened criminal, he is a habitual offender, there may be other convictions also to his credit or discredit. Now, there was a doubt as to whether, while framing the charge for the main offense to be tried, the charge for previous conviction also could be framed. That was the doubt. Now, under the old code, it was impermissible, but under the new code, the 1973 code, they say the charge for previous conviction also can be framed along with the main charge for the offense to be tried. But there is one rider. The plea of the accused should not be taken. Even though the magistrate is entitled to frame charge for previous conviction, the plea of the accused should be taken only with regard to the offense to be tried, not with regard to the previous conviction. And the prosecution should not bring in the factum of previous conviction anywhere until the accused is convicted of the main offense. Until the accused is convicted of the main offense, the prosecution also should not bring in the factum of previous conviction to the accused, because that will prejudice the mind of the court and as well as the accused also. The accused will feel that I am sure to get punishment because there is a previous conviction. Just because he has been previously convicted doesn't mean that he should be convicted in each and every case. 249, absence of complainant. You may note the death of the complainant in a complaint case does not cause abatement of proceedings. This is what the Supreme Court said. In a complaint case, just because the complainant is dead, it does not cause abatement of proceedings. Ashwini Nanu Bai Vyas. Ashwini Nanu Bai Vyas versus State of Maharashtra. AR 1967, Supreme Court 983. 3 judges. Authorized Justice M. Hidayatullah. Then, Section 249 CRPC has no application if charges were framed and the complainant died thereafter. This section has no application if after the framing of charge, the complainant died. So the proceedings will not await. K. Chatukutti versus K.S. Prasanna Venkateshan. 2007 1 KLT 584, corresponding to 2007 Criminal Law Journal 1120. The judges are J.B. Koshi and K. Padmanabhan Nair. Author of the judgment being K. Padmanabhan Nair. Then, yet another proposition is evidently, Section 394(1) CRPC has no application to cases of death of complainant in an appeal against acquittal presented under Section 378(4). The words every other appeal under this chapter excludes appeals filed under Section 377 and 378 of the CRPC. The result is that an appeal filed under Section 378(4) against acquittal does not abate on the death of the complainant. So, this court cannot dismiss a criminal appeal as abated. The appeal is to be heard and disposed of on its merits, is what the LI court, the same bench. K. Chathukutti versus K. Prasanna Venkatesan, 2007, 1 KLT 584, corresponding to 2007 Criminal Law Journal 1120. Justice J.V. Kushi and K. Padmanabhan. Then, same decision, they laid down one more principle. Even though there is no provision for impleading the legal heirs of the deceased appellant, the court can, under section 302 CRPC, 302 of the CRPC, allow the legal representatives of the deceased appellant to come on record and prosecute the appeal. Same decision. 2007 Criminal Law Journal 1120. That takes us to section 250 CRPC, that is compensation for accusation without reasonable cause. Now, the conditions for application of this section are: the case must be instituted upon a complaint under section 2D CRPC or upon information given to a police officer or to a magistrate. If the criminal law was set in motion by means of a complaint or by means of information given to the police and or to the magistrate, and if that case ended in acquittal or discharge, and the court said that there was no reasonable cause for initiating this prosecution, the accused is entitled to compensation under section 250 CRPC. The second condition is the case must be triable by a magistrate. Third condition is magistrate must be satisfied that there was no reasonable ground for making the accusation against the accused. Fourth condition is action must be taken simultaneously with the discharge or acquittal of the accused by calling upon the complainant forthwith to show cause why compensation should not be avoided. It cannot be taken at a later phase. As soon as the court acquits the accused, magistrate acquits the accused or discharge the accused, you should call upon the complainant immediately to show cause why you initiated this prosecution without any reasonable cause. Fifthly, before compensation is granted, sufficient time should be allowed to show cause. He should be asked to he should be asked to show cause immediately, but for that he should be given time. The acquittal or discharge order must show on the face of it that there was no reasonable ground for making the accusation against all or any of the accused. The magistrate should not be slow to make use of this section in appropriate cases to stop not only the abuse of their own process, but also harassment of innocent people. Very often magistrates do not exercise this power, maybe because of the roster. Emperor versus Jahangir M. Jasawala, year 1948, Bombay, 6, corresponding to 1947, 48 Criminal Law Journal 9-9. Justice, that is Leonard Stone, Chief Justice, was the author of the judgment. All these principles are laid down. Then there is one decision of the Supreme Court also, that is the same magistrate who discharged or acquitted the accused alone can initiate action and pass final orders under this section. The successor magistrate, succeeding magistrate cannot continue the proceedings initiated by his predecessor in office. Nandakumar Kishan Rao Navagire versus Ganpat Lakshman Kushalkar. Kushalkar versus Maharashtra. Kushalkar versus Maharashtra. 1998 2 SEC. 1998 volume 2 SEC 355. This is M. Punji and K. Venkadaswamy J. Then reasonable and probable cause within the meaning of section 250 CRPC means an honest belief in the guilt of the accused based upon a full conviction founded upon reasonable grounds of the existence of the state of circumstances which, assuming them to be true, would reasonably lead it to any ordinary, prudent and cautious man placed in the position of the accuser to the conclusion that the person charged was probably guilty of the crime imputed. That is, he is placed, the complainant should be placed in the position of, court to be placing in the position of the complainant. That is, a reasonable and prudent man. What would have been the conduct of a reasonable and prudent man placed in similar circumstances if he readily prosecuted the person? That is the good yardstick to consider whether there was reasonable and probable cause for the prosecution. The Kuhn's bench decision, Hicks versus Faulkner, 1881, 8 QBD 167, Hawkins J. This was approved by the House of Lords in Herminan versus Smith, 1938, All England Reports, page 1, House of Lords. 5 judges, Lord Atkin was pronouncing the judgment, author of the judgment. And the order of discharge or acquittal must show on the face of it that the prosecution of the accused was without reasonable cause. The order itself should show or state that the prosecution of the accused was without reasonable cause. Then only it gives rise to a cause of action for filing for seeking compensation under section 250 CRPC. Bijoy Krishna Chandra versus State, AR 1958, Calcutta, page 121, corresponding to 1958, Criminal Law Journal 364. Devabrata Mukherjee, Justice Devabrata Mukherjee. This takes us to the end of today's session. Thank you. Yes, Mr. Vikas.
Just hold on. Somewhat during this integram, the throat has gone from bad to worse. This is one question. It says, if in a pre-charge cross, one of the witnesses whose statements on record refuses to be crossed can be accused, seeks his witness again in a post-charge cross. And if he refuses, can the statement on record be ignored as evidence to be of no consequence by the...
I didn't get the question.
So the question...
Pre-cross, what the witness did?
Should I read the question full?
Yes.
If in a pre-charge cross, one of the witnesses whose statements are on record refuses to be crossed, can the accused seek his witness again in a post-charge?
Can they?
Can the accused seek his witness again in the post-charge? If he refuses, can his statement on record be ignored as evidence of no consequence? So this question is at 642 on the chat box.
I can't see that. Anyway, he can again seek recross after the framing of charge. Post charge cross-examination also he can seek permission of the court for further cross-examination, which is his right. See, earlier cross-examination, pre-charge cross-examination, very often accused do not exercise. They will leave it to the post-charge cross-examination. Very often accused do not exercise that right. But after the framing of charge, when an opportunity is given, they will definitely cross-examine the witness. So in this particular problem, he had already exercised his power right under the pre-charge cross-examination. That doesn't preclude him from again cross-examining the same witness after the framing of charge. Nothing, no inhibition.
The complainant has passed away after a post-charge stage. Kindly advise which section saves the case that it cannot be abated in favor of the accused. To be
I didn't get you.
So the complainant has passed away. That is, he has died. At a post-charge stage, kindly advise which section says that the case cannot be abated in favor of the accused.
I have already given the citation. After the framing of charge, the complaint doesn't abate. Even if the complainant dies, doesn't abate. There is no abatement. Yeah, and Kerala High Court has taken the view that the legal representatives of the person can come on record and prosecute the proceeding further, continue the proceeding further.
And the last question is, if the complainant is absent continuously and offence is cognizable. Is there any way to get the case disposed of?
There is only court. The magistrate should make an honest endeavor to procure their presence by issuing even coercive steps, taking coercive steps. If even after taking coercive steps, their presence cannot be secured, magistrate has no other go. He can discharge the accused. That is only way he can discharge. He can definitely.
This is by Dr. Jayasimha. When the accused who pleads not guilty and seeks to cross-examine the prosecution witness, under what circumstances the magistrate can refuse to summon the PWs?
No, magistrate cannot. Magistrate cannot refuse to resummon the prosecution witnesses after the framing of charge. And if he has pleaded not guilty.
Thank you, sir. Have a blissful time in Dubai and keep sharing knowledge with us. We are thankful to you.
Yes.
Thank you.
Today morning I was having a very bad cold, but it's gone.
That energy and the prayers of the